Good morning, and thank you so much for the kind presentation and also the invitation, Agnes Gabor, to be here today. It's a pleasure and an honor for me, and also to the organizers for the fantastic and smooth organization of the event. So yesterday we already discussed some of the issues that I wanted to talk to you about today. So the brilliant speakers yesterday made my life quite easier for today. And the topic will be the jurisdiction and admissibility of preliminary references. Actually, it's probably not the most appealing topic for 9 o'clock in the morning, but still a relevant one from the perspective of getting through Luxembourg's doors. So I focus then on those two issues, jurisdiction and admissibility, from the perspective of fundamental rights and, in particular, judicial independence too. We already heard about the importance of the preliminary reference as a unique avenue for an ongoing dialogue between domestic courts and the Court of Justice of the European Union. Among political scientists, the empowerment thesis became very popular to explain why domestic courts collaborated with the Court of Justice of the European Union, and particularly lower courts, to the extent that they were empowered vis-à-vis higher courts in the system and also other political institutions at the domestic level. But that empowerment, to some extent, came with a cost or a trade-off, if you want, which is the alliance with the Court of Justice of the European Union. And from that perspective, also, we can see how domestic courts have contributed to the interpretation of fundamental rights at the EU level. And borrowing from Sara Iglesias yesterday, they have become co-creators of EU law. Right? Through their references, even we can say they have the capacity to some extent to set the agenda of the court. From the perspective of the fundamental rights, actually, we already heard about how key the preliminary reference has been in terms of protecting rights in the European Union, creating rights when rights were not still written down in the Charter as general principles of EU law, and how actually the Charter has had an impact in terms also of how the preliminary references were framed. And actually in this report that the Fundamental Rights Agency issued on occasion of the 10 years of the Charter, you can see here some data on how the use of the Charter in preliminary references has increased over time, from about 6% when the total preliminary references when the Charter acquired legally binding force with the Lisbon Treaty. And as an average, it is said that 12% of preliminary references quote the Charter, but we can see how the trend has been an increasing one in terms of making use of the Charter. At the same time, the report indicates some obstacles still for a full application and use of the Charter at the national level that have to do actually with some of the issues that we are just going to discuss today. Such as first, actually, the scope of application of the Charter, as one of the main obstacles from the perspective of national courts in using the Charter. Sometimes it is also mentioned the unspecified standing of the Charter. We know the Charter is part of primary EU law and this is binding and so on. But to some extent, for national courts, the Convention is still the main document for the protection of fundamental rights. Also, the obstacles, they mentioned the distinction between rights and principles from the perspective of when Charter rights are directly effective or not. And finally, the lack of experience or knowledge about the Charter at the national level. So that's why the Commission is funding programs such as this one. Going back then to the presentation here, we know how the preliminary reference has become then a main instrument to check the compatibility of national legislation with EU law in general and the Charter in particular, although this is not the way it was designed. So let's start then with jurisdiction. Here we are talking about the competence of the court, right? Like the boundaries of the Court of Justice adjudicative power. And here we need to be aware that actually the court is interpreting the boundaries of its own power, right? So according to settled case law, the court may interpret EU law only within the limits of the powers conferred on it. And the question is, well, how to define those powers? Here, we need to exclude then purely internal situations. These are defined as situations confined in all respects within a single member state, but already the interpretation of what is a purely internal situation might be contested. And actually, in this decision, the court found that even in purely internal situations, sometimes we can find links with EU law that then confirm the jurisdiction of the court over the case. But what I wanted to focus on actually from the perspective of fundamental rights was precisely the scope of the Charter, as Agnes asked me to do. Although I think that we already heard about that yesterday. We spent some time actually during the first hypothetical discussing precisely this issue, which is very relevant actually from a constitutional federal perspective on the architecture of the system of rights protection in the EU to understand when the member states are bound by the Charter. And here the answer to some extent is given by Article 51, paragraph 1, but obviously this article was actually very much contested during the drafting process and afterwards, as we discussed yesterday. So this provision indicates that the Charter is, yes, binding on the member states only when they are implementing EU law. So the question is actually how to interpret that. And I'm not sure, I mean, I understand that many of you are already familiar with that, and just focus on certain aspects and move faster here, since we had the chance to discuss this yesterday. The leading case, the first case actually in which the court confronted the interpretation of Article 51, paragraph 1, was precisely the one of Ackerberg Franzen. You know about this Swedish fisherman who had already been financially fined for providing false information regarding the value-added tax, and then a criminal prosecution started. And then he argued that, well, this was against the principle of non-bis in idem, and a preliminary reference was submitted to the Court of Justice. This case presented at first a dilemma, to the extent that, as the Swedish government was arguing, the Swedish Civil Code had not been enacted to implement EU law. So therefore, the argument was this is a purely internal situation, and the Court of Justice does not have competence here. However, the court first interpreted the clause only when states are implementing EU law in a broad way, to understand that in general situations that fall within the scope of EU law are going to be bound by the Charter. And here the link was found actually in an article of the directive on the common system of value-added tax, and also an article on the treaty functioning of the European Union, that you see they impose obligations to take measures, but in a very general way, right? But to the extent that the state was under those obligations to take measures in order to ensure the collection of the value-added tax, and that the financial interests of the Union might be at the stake, then the court confirmed its jurisdiction under the Charter. So, the question, when does the Charter apply? Here, I advise you to check the materials that the Fundamental Rights Agency has produced. They have this handbook on applying the Charter of Fundamental Rights of the European Union law, in law and policy making at national level. And you can easily access these materials, the handbook and other more practical materials through this link. You need to register, but then you can freely access all these materials that might be helpful. Actually, this handbook includes a checklist in order to determine whether the Charter applies or not in a given case. So, the basis of the handbook, actually, we know that there must be a sufficient connection with EU law, but that not every link with EU law is going to be sufficient. So again, this is a matter of interpretation, right? When the link that we might identify with EU law is sufficient in order to trigger the application of the Charter. And usually on the basis of the case law, we might identify the situations and several types of situations in which the Charter is applicable. Yesterday, Martin made reference to those. So just, I'll go quickly through this. First, we have the agency situation, in which generally we are talking about cases in which the member states are applying, executing any sort of EU law, the treaties, regulations, directives. And here, more specifically, we have the most common situation, or the easiest one, when a national act directly transposes a directive. There we don't have doubts. But there are also cases in which national legislation is not intended to implement EU law, but still falls within the scope of EU law provision. Here we have the example of Seda Kukuk-Deveci on non-discrimination on the basis of age. And actually, the national provision at the stake was an article of the German Civil Code. The Civil Code, German Civil Code has not been enacted in order to implement the directive on equal treatment in the workplace, but still, to the extent that it is in the scope of the directive, then that confirms the application of fundamental rights. Then we have situations also in which the member states are using discretionary powers under EU law. The example here is the case of NS. You probably know about that one too, in which this is an asylum seeker in the UK, and the question is to what extent the transfer to Greece would violate the Charter. Here, again, the question is, well, to what extent this is a situation covered by EU law, to the extent that the argument was in deciding whether to decide about the asylum application in the UK or to transfer the asylum seeker to Greece. The state is not implementing a provision of EU law. But the court argued that, well, in using this discretionary power, still the state is under the scope of EU law. And finally, here we have also national acts involving remedies, sanctions, or enforcement under an obligation following from EU law, such as the case of Ackerberg-Franzen. So in all those situations that go beyond strict implementation of EU law, the Charter will apply. Also, we have a second group of situations in which the member states need to rely on an authorization under EU law. These are cases in which the states take measures restricting from free movement under the exceptions provided by the treaties or the overriding requirements for the public interest admitted by the Court of Justice. So in those sort of situations, you could say, well, the state is not implementing EU law in the sense that we discussed before, but still the states are acting under the exceptions provided for by EU law, and then they are going to be bound by the Charter too. There is a famous case here, a Hungarian one, on a law that prohibited the slot machines outside casinos. And the question, again, was whether this was covered by the Charter, whether this law had to comply with the principle, with the right to property. Well, the link here with EU law was the freedom to provide services. So to the extent that this law was restricting freedom to provide services, still it could be justified under the overriding requirement related to the prevention of gambling and crime. But then the Charter would apply too. Still, the restriction on the right to property could be justified under proportionality, but the issue here was that the Charter was also applicable. Then the court has found other avenues to trigger the application of the Charter that sometimes we can say go beyond Article 51, paragraph 1 to some extent, such as Article 20, right? The status of EU citizenship. And this is something that we discussed actually yesterday. Here, well, as we know, the leading case was with Zambrano, in which, again, we could think that with Zambrano, we were confronted with a purely internal situation, right? This was a third country national who was going to be expelled. He had 2 children of Belgian nationality, but none of the directives were applicable, the free movement of citizens or the directive on family reunification. So again, here it was the domestic judge, the one that made the reference to check whether actually EU law would be applicable in the case. So we can confront cases that at first seem to be purely internal, but then we can find ways as judges to actually ask the Court of Justice to what extent the case might be covered by EU law, and then we can grant protection under EU law. And here the trigger was precisely EU citizenship, right? And the court ruled that the expelling the father would have the consequence that the children would be forced to leave the territory of the Union, and then their rights as EU citizens would be undermined. And the court used this broad clause, right, according to which national measures would have the effect of depriving citizens of the Union of the genuine enjoyment of the substance of the rights conferred by virtue of their status as citizens of the Union are against Article 20. But this had a great potential, right? Which rights are we talking about, and what exactly this means? And actually, in subsequent cases, the court cannot restrict the potential scope of a clause such as this to focus on situations in which the minor children might be, as we were saying, forced to leave the territory of the Union in order for EU law to protect in those cases. And the Court of Justice places a lot of emphasis on the sort of relationship of dependency that exists, as actually the case in W and PQ, which was the case that we discussed yesterday. And it's interesting to see how in many of these sort of cases, the court doesn't even mention the right to family life. So these are cases decided mainly on this notion of EU citizenship, and EU law will apply when we are in this sort of situation, right, that minors might be forced to leave the territory of the Union. But as national judges, you can actually test the court regarding other situations, right, of dependency that do not necessarily concern minor children, and see how this is an evolving area of the law. And then we get to judicial independence, because here in the context of the rule of law backsliding, cases reach the court about actually the domestic organization of the judiciary. So the question here is, well, to what extent are these purely internal situations? Has the Court of Justice competence regarding these rules on the domestic organization of the judiciary? Well, first, the court said clearly that although this is a field of state competence, still member states are required to comply with the obligations deriving from EU law. So what obligations are those? Is the charter applicable here? Again, the court found a new route, right, in order to give protection under EU law on the basis of Article 19, paragraph 1. Right, so you know, this article lays down that member states shall provide remedies sufficient to ensure effective legal protection, and that includes the obligation to be independent in order to be able to offer that effective legal protection in the fields covered by Union law. So the question is, well, what are those fields? And the court, already in the leading case here, the Association of Portuguese Judges, told us that this is different from the scope, acting within the scope of EU law or implementing EU law in terms of Article 51, paragraph 1. So that Article 19 may apply even if the Charter does not. So then how to define that? When does Article 19, paragraph 1 apply? And here the court said that this article applies to any national body which can rule as a court or tribunal on questions concerning the application or interpretation of EU law. So it is not necessary that that court has applied EU law in the past or that the court is applying EU law in the case at hand. It's just that any court that may potentially be called to apply or interpret EU law. So these are all courts in domestic legal system, including constitutional courts, right? So is the scope of Article 19, paragraph 1 unlimited? Well, from an institutional perspective, it seems so, right? That any court, to the extent that EU law has penetrated all fields of law, that any court might be called to interpret or apply EU law at some point. Is it substantially unlimited too? So can any issue regarding the domestic judicial organization then be covered from, well, appointment, composition of courts, disciplinary regime, allocation of cases? Well, the court hasn't restricted the scope of Article 19 from this substantive perspective. There are proposals from advocates general saying that Article 19 should only apply in cases of structural problems, systemic or generalized deficiencies, but the court hasn't taken that route explicitly, and that gives the court flexibility in then approaching the cases that get to this. And now it's the time to turn to admissibility quite fast. Since there we'll see how the court has set then some limits. Actually, admissibility requires to comply with the requirements of Article 267 and the rules of procedure. I'll refer to Article 94 in a minute. In general, there is a presumption in favor of the relevance of preliminary rulings, which is encouraging for the domestic courts, but there are limits. And here I'm going to focus on two sorts of limits: the concept of what a court or tribunal is, and then this requirement of the necessity of the answer of the court in order to resolve the specific case. So I think I can go pretty fast here regarding who may submit a reference. What is a court or tribunal for the purposes of Article 267? The court has understood that this is an autonomous concept, so governed by EU law alone, regardless of how those bodies are regarded at the national level. In the past, the court interpreted this notion quite broadly in order to favor dialogue and the uniform interpretation and application of EU law. And basically, the requirements according to established case law are the ones that you can see here. And I'm going to focus on the requirement of independence, because this has evolved, and in the context of rule of law backsliding, it has been reinforced. So we have an evolution here from Gaval-Frisa to Banco de Santander. And Gaval-Frisa, this is a case in which the court accepted the preliminary reference that came from the regional tax tribunal in Spain, whose members were appointed by the Minister for the Economy and Finance. But then in Banco de Santander, already, when the rule of law saga had started, the court interpreted this requirement of independence in a more rigorous way and emphasized the element of external independence and specifically the principle of irremovability, to the extent that now this was the Central Tax Tribunal, its members are appointed and freely removed by the government. So the court ruled here that this was not regarded as a court that could make a use of the preliminary reference. The things got a bit trickier, with getting novel value. We already discussed this case yesterday, so I'm not going to go into that. As you know, here the court crafted this presumption of independence that is rebuttable. right? But it has been discussed whether this is a good way to go in this context. This presumption has already been rebutted in a case, the LG case, regarding the Chamber of Extraordinary and Public Affairs. That the court took into account that already the European Court of Human Rights had declared that this was not a tribunal established by law, and actually a domestic decision too, to say that this body could not make a preliminary reference to the extent that it is not independent. So there are reasons to be against this presumption of independence for the creation of double standards. Also, to some extent, the court seems to be externalizing the assessment in the basis of decisions coming from other courts, the European Court of Human Rights or national courts, and it's legitimizing judges who actually like independence. On the other hand, we can understand that we are talking about different functions here, how do we understand independence on grounds of Article 267, and then the standards that we apply for Article 19, paragraph 1. Also, we can see how the court then is connecting its own case law with the standards coming from the regional Court for the Protection of Human Rights here and also national courts. And finally, that this presumption enables then judges that might be under attack to reach the court for the protection of their own independence. Finally here, the criterion of relevance and necessity, right, on the basis of the rules of procedure, and particularly Article 94. Here, Article 94 is telling us the need to, to be clear about our questions. I'm sure that Raluca is going to cover this article with more detail, and the need also to give the Court of Justice the legal and factual context to understand the sort of dispute at the national level, and also to state the reasons to raise the question, and also the relationship between EU law and the dispute at the national level, so that our preliminary reference can get inadmitted for failing to comply with these requirements. And actually, according to the court, one may refuse a preliminary reference when it is obvious that the interpretation of EU law has no relation to the actual facts of the main action or its purpose. It's just hypothetical, or it doesn't have this factual and legal background. So this admissibility criterion has gotten quite complex in the field of judicial independence, and I'll use here the case of Miastolovic to see the sort of situations in which the court will rule that this criterion of necessity exists. So Miastolovic is interesting because these are two preliminary references coming from the Regional Court of Warsaw and Lodz, and actually the cases were unrelated to EU law. The substance of the cases were about criminal organized crime and the liability of the state treasury. But the judges here argued that as a consequence of the new disciplinary regime and so on, they fear that as a consequence of the content of their decisions, disciplinary proceedings could be started against them. So it's interesting to see here how the Court of Justice first confirmed its jurisdiction under Article 19, paragraph 1, right? It said these are courts that may apply or interpret EU law at some point. They are not doing that in this case, in these cases, but still, these are courts within the field of EU law. So I have jurisdiction under Article 19, paragraph 1. But under the admissibility test, the court said there needs to be a connecting factor between the dispute and the provisions of EU law, so that my interpretation is objectively required for the decision to be taken by the referring court. And here we can identify three categories of connection, or three ways to establish that connection between a dispute and EU law. First, when there is a substantive connection, right? So that the interpretation of EU law is necessary in order to answer the specific dispute in that case. So the Court of Justice said, well, this is not the case in Miasto Lovic, because the disputes in the main proceedings are not substantively connected to EU law. We don't need to interpret Article 19 for the domestic judges to be able to give an answer from a substantive perspective. In contrast to, for instance, the Association of Portuguese Judges case, in which we confronted the state measures that reduce the salary of judges. So the interpretation of Article 19 was needed in order to determine whether the national measure was compatible with EU law or not. The second category has to do with questions on the interpretation of procedural provisions of EU law which are applicable to the case. And here we can refer as examples to the cases about the European arrest warrant. And for instance, in LMP, there is a specific question about whether in the case of systemic deficiencies, the issuing judicial authority can still be regarded as a court for the purposes of the framework decision on the European arrest warrant. And the court answered that, well, even if there are systemic deficiencies, doesn't mean that all courts lack independence, so still the issuing judicial authority can be conceived as a judicial authority under the framework decision. And finally, and this is the most complex category that has to do with questions about the interpretation of EU law that enable the referring court to settle procedural questions of national law before they can rule on the substance of the dispute. So these are questions in limine litis, right? That procedural issues that need to be decided before giving an answer to the substance of the case. And here the example would be the 8K case, in which there was a question about the independence of the new disciplinary chamber of the Supreme Court, and the Court of Justice understood that that was relevant from a procedural perspective in order to determine whether the Supreme Court that made the question, the labor chamber, was competent in that case instead of the disciplinary chamber, right? So there are other cases under this category. I'm not going to go through them. The Procuratura Rejonova case, I think it's very useful to kind of see the sort of challenges to admissibility in this field. But in any case, in Miasto Lovic, in the end, as we know, the court refused admissibility, right? Because it understood that the interpretation of EU law was not necessary even to give an interpretation to the national provisions or to check whether national provisions from a procedural perspective were compatible with EU law. However, if courts, these judges fear that disciplinary proceedings could be instituted against them, we might think that, well, they might not be able to decide independently, right? So, but, just to conclude here regarding admissibility, the case law shows a high degree of complexity in this field, and sometimes it might be even difficult to foresee the answer of the court, which might undermine legal certainty. So, in framing the preliminary references, it is important to be very specific about the questions, to provide the legal and contextual framework for the court to understand what's at stake, and then to be very specific and clear about why the answer is needed in that case. So, as we have seen over time, the court has expanded the boundaries of its jurisdiction. The clause, only when implementing EU law, has been interpreted to include situations falling within the scope of EU law. The obligation under Article 19, paragraph 1, applies to all courts in the system. So this expansion of the boundaries of the jurisdiction has been tamed to some extent by the admissibility requirements that still can be understood either from a substantive but also from a procedural perspective. So in this context, I think that Article 19, paragraph 1, opens the door for a full application of the Charter in terms of arguing that, to the extent that the obligation to provide equal protection might be the obligation to provide effective protection might be undermined, if national courts fail to protect any of the fundamental rights of the Charter. So I think that this legal argument can be made, although politically it might be unfeasible at this time. And finally, well, the preliminary reference in practice has become, I think, an instrument for judges to protect their own independence, but we shouldn't lose sight that by protecting their independence, in the end, they are also protecting the right to a fair trial of individuals. So thank you so much, and I'll be happy to answer any questions later.